guns, and money. Send lawyers, guns, and money.
Welcome, everybody, to episode 59 of Conduct Detrimental. I'm your co-host, Daniel Wallach. Joining me today, as always, is my co-host, Dan Lust, for what seems to be a continuation of Big Ten drama or conduct detrimental in Nebraska. So tee it up, Dan. We have a special guest, don't we?
Special guest. We're going to try to keep this episode pretty tight, just one topic, and that topic is a conversation with Tom Mars. He's the college football attorney. You know him from a couple cases. There's a very famous case he had with Mississippi, the big transfer dispute with Shea Patterson, also Justin Fields, and now he's at the heart of this Big Ten dispute. So we reached out to Tom in the world of Twitter. Somehow Tom responded, and we had him on the show.
Yeah, what's really interesting is he's a premier trial attorney with significant experience handling class action work and vindicating rights of clients in courts all over the country. But his role in the Big Ten Nebraska controversy, or just the Big Ten controversy, is limited to submitting a series of public records requests or Freedom of Information Act requests to public universities in an effort to gather information voluntarily from the schools as to the circumstances surrounding the vote. And he's trying to accomplish through the FOIA process what the Nebraska 8 football players are trying to do through the court system somewhat. So there's a little bit of an overlap.
We're going to get into it. I mean, the way that Dan and I see this, I mean, I think you can agree with me. It's almost like multiple guns are being pointed at the Big Ten from different directions. So obviously want to ask Tom about his interplay with the Nebraska suit, how involved he is, and really where he sees this going. So I'm good to jump straight in, Dan, unless you have anything else.
I just hope for our next episode, we can find a topic other than the Big Ten, but I have a sneaking suspicion that this is going to remain in the news a little while longer. You know, we had a court ruling yesterday, and Tom's public records requests are such a fluid situation that I think that this is really going to remain not only in the news, but a major story until there's some resolution as to what happens to the Big Ten's football season. So it wouldn't surprise me.
Agreed, Dan. Let us send it over to our friend, Tom Mars. Here is Tom Mars. Tom, welcome to Conduct Detrimental. We've been talking about your work for the past couple of weeks, so it's truly a pleasure to have you on. How's everything going on your end?
Great. Thanks for having me on, guys.
I'm not sure if everyone's familiar with Tom's work. Tom maybe is the de facto college football attorney. He's been involved in a lot of high-profile cases from Mississippi. The one that I came across Tom for the first time was this Justin Fields case when he was helping him transfer. So, Tom, if you can, for those that aren't familiar with your background, can you speak a little bit, about where your practice is based, the type of work that you do, and how you fell into this weird intersection between the law and college football?
Sure. I spent most of my career as a lawyer in Northwest Arkansas, mainly as a trial lawyer. I also spent almost 12 years at Walmart, about 7 as the chief legal officer and about 3.5 as the chief administrative officer of Walmart US. I also did about a 3-year stint as director of the Arkansas State Police when Mike Huckabee was governor. I worked for Mike Huckabee and also been his personal lawyer, but also worked directly for Hillary Clinton at the very beginning of my career for about 5 years. I've briefly been the CEO of the Stedman Clinic out in Vail, Colorado, but mainly I've spent my career as a trial lawyer. How did I end up in this? Well, it's the most accidental thing in the world because I used to live next door to Houston Nutt when he was coaching the Razorbacks, but I was busy suing people in 3 years or so. I lived next door to the coach, but I never met him. And fast forward until about March of 2017, I got a call from a close friend of mine who's a mutual friend of Houston's who wants me to talk to Houston about this NCAA matter in Mississippi. And this friend of mine, Rex Horn, knows me well enough to know that I don't know anything about college football. Didn't know anything about college football at the time. I know a little bit now. But he wanted me to talk to Houston. I ended up representing Houston in this case against Ole Miss with the help of Steve Robertson, this fantastic Mississippi State fan and journalist. Stumbled across a suspicious phone call on Hugh Freeze's university phone, at least when you check online, connects to a hooker in Tampa, Florida. A week later, he gets fired, lawsuit gets filed, Ole Miss digs their heels in, claims they didn't do anything wrong, and off we go for several months of some pretty contentious litigation. And within a couple of days after a new complaint was filed, they decided they'd had enough, and they publicly apologized to Houston Nutt and acknowledged what they'd done. And I went back to just regular law practice, commercial litigation mainly. And about 2 months later, I got a call from Deontay Anderson's father in Houston. Deontay was an Ole Miss safety and wanted to transfer, and I had this information from the Houston Nutt case. And so when Mike Anderson asked me if I'd help, I felt obliged to say yes. Nobody else had this information. And little did I know, these Ole Miss football players' parents were all talking, And so by 3 weeks later or so, I agreed to help 6 of these Ole Miss transfers, the highest profile being Shea Patterson. And on April 27th of 2018, Shea got his waiver that day, worked out an agreement where all the other guys got their waivers. They were staggered out over the next few months. And then I just started getting phone calls from people all over the place, but not just football players, mainly football players, but baseball, basketball, volleyball, tennis players. So it sort of changed the shape of my law practice. And I was with a law firm at the time in Arkansas, but I decided to open my own practice a little over a year ago. And now work that I'm doing for coaches, and my practice is now probably 80% college sports with some professional sports as well. But the vast majority of what I do nowadays is in sports. Something I never intended. It was all just accidental.
So, Tom, we wanted to have you on here. We have a lot of law students who are obviously interested in the career path. Dan and I have our own stories how we fell into sports, similar to you, just a happy accident. But at the end of the day, Tom, you are one of the big names in college football legal field because you're a fantastic lawyer. Why we wanted to have you on today, September 3rd was supposed to be the opening game for the Ohio State Buckeyes among a number of Big Ten teams. Obviously, there is no Big Ten football scheduled for the fall as of today, and we'll see if it happens in the spring. So, Tom, you're at the kind of center of this conversation because you are in the process, and I know you've been working on these updated FOIA requests that you're sending to the university. So I'm more happy to kind of dive into it. But what we've kind of explained, that these FOIA requests are public, we'll say discovery requests for documents, information, materials from the universities involved. Now, that being said, I know there's been some updates in the requests, and it's been maybe a week or so since you filed these. So maybe you could fill us in, on the current status and what you're trying to achieve with these requests.
Sure. So in this Big Ten debacle, if I can call it that, you have 13 public universities and 1 private university. And one of the greatest weapons available to a trial lawyer who's dealing with a litigation matter involving a university or any state agency is the Freedom of Information Act in that particular state. Now, I'm not involved in the Nebraska litigation. I'm not involved in any litigation at all, and I don't plan to be. I got into this because my phone started ringing that weekend when the decision was made. I got into this thinking I could help with some Freedom of Information Act requests because that happens to be something I've been very involved in since I got out of law school. In fact, the reason Mike Huckabee hired me to be his lawyer was because the Attorney General of Arkansas had sued him under this State Freedom of Information Act, and I was known to be a lawyer in Arkansas, had some experience in that area. And so this is something I've dealt with for my whole career, and I knew I had the unique background and skill set to do that.
Can I ask you a question about the key difference between using the courthouse and the judicial system versus using a public records request? Now, I've been on both sides of public records requests, both as the requester and as somebody advising the recipient, and the one distinction is that unlike the court system, the recipient remains in control of the process. Yes, there are some statutory requirements as far as, response deadlines, but I would think it's fairly easy for a public agency to kind of run out the clock on you. We're talking the 2020 Big Ten season, and you could be hit. When you get these responses, you can get objections and various exemptions from public disclosure that are claimed. And one of the common ones that I've seen in these responses are that the records that the request seeking are either to institute commercial or financial information which may be exempt from disclosure. So how do you get around that, knowing that there's a ticking clock and that the school remains in control of the process?
You're absolutely right about the recipient being in control. I'll say this, that I've had mixed experiences, but the vast majority of universities that I've dealt with making Freedom of Information Act requests have been ridiculously obstructive, and they've done it in a variety of ways. The most notable, and when I was trying to get phone records out of Ole Miss, believe it or not, they took the position that I'd have to pay the cost of having their lawyers review all those phone records, and the bill, or maybe I should say the ransom for the right to look at the phone records was $25,100. And they actually put that in writing. Now, cautionary tale here for universities, big mistake. Why? Because I took that letter and I went straight to Dan Wilken at USA Today, to Pat Forte, who was at Yahoo, and other sports writers who I'd gotten to know. And of course, they expressed their opinion in columns, and I jumped on Ole Miss with both feet. And within a matter of days, they did a complete U-turn and gave me all the phone records. You know how much they charged me? Zero. They just wanted out of that trap. That's an extreme example, but what I'm seeing across the board in the Big Ten, and I just said so in a letter that I wrote to Purdue and delivered within the last hour. I wrote back to a lawyer who had responded with the latest variation of a dozen reasons why I couldn't have these records. And I said that I note that your response, Purdue's response, is not unlike the responses of other Big Ten universities, all of which.
Some of them that you posted on Twitter too, that we had great amusement.
You know, and I'm not going to say which university it is, but what bothers me about this more than anything is that most of the people that I'm dealing with in these universities are lawyers, mainly young lawyers. And I know they have a client and they have to accommodate what their client's desires are, but they push things to a limit that is disturbing because they're not just lawyers, they're public servants too. The public owns these documents. And I received an email yesterday. This lawyer cites two cases and asserts that these two cases stand for the proposition that the way my request is worded, they're not required to answer. Well, I guess he didn't think I was going to go read those two cases. They're not from Arkansas or Georgia, but the cases read the same whether they're Georgia, Arkansas, or Montana.
It's a big assumption that you're not going to read the cases he's citing, that you're not going to get these documents. It's a pretty big leap.
Here's what disturbs me, and this is one of these cases is a prisoner petition that has nothing to do at all with the proposition that he asserted in his email. So it didn't have anything to do with it. The second case wasn't any more on point, and it just really irks me. You want to play games? Fine, but you got to play by the rules. You can push the boundaries, but don't walk over the line. That disturbs me. But to answer your question about, well, how do you deal with that? I think that's where I mentioned I've had these different roles as a lawyer. And I think that's what's made me more effective at this point in my career than I ever was before.
So, Tom, when we do the podcast, we like to kind of separate this out in segments. So we'll say that segment, if we're going to put a bow on it, is who Tom is, his kind of arsenal. We'll say his legalese. The reason we want to have you on, I try to kind of forecast what's going to happen. So I think there's three things, obviously, we want to talk to you about. I want to talk to you about where the FOIA stuff is going to go ultimately, the Nebraska stuff, and then I have a looming issue with these potential transfers coming from the Big Ten. So just so you see where we're at. So first and foremost, 8 Nebraska players sued the Big Ten conference. Now, separately, you have your FOIA request. So, we'll say the Big Ten's getting hit from 2 different angles. Yesterday, we had a decision that came down. Nebraska State Court ruled that the Nebraska players, 8 of them, could get limited discovery pertaining to this vote. They were not going to be told who voted exactly in what direction, who the 11 and 3 were, even though, I think there's been some leaks about what's been out there, but they're going to get limited discovery. So, Tom, I'm going to turn it over to you, and then I'm sure Dan's going to have some follow-up. Did you expect that result, and what do you see to come from this lawsuit ultimately?
I did expect that result, and you don't have to take my word for it. You can just look on Twitter, because a few days before the ruling, I predicted that this would happen and that this might just be the beginning of some unpleasant legal consequences. That's the term I used. I wasn't at all surprised. I would have been surprised if the judge hadn't made such a ruling. And the reason? The reason is because either through a lack of situational awareness or lack of governance, internal controls, or lack of common sense, or something along those lines, in my view, the Big Ten made a colossal tactical mistake in filing that pleading and saying that in affidavit form, under oath, that there was a vote of 11-3. Why do I say that? Because anybody paying attention knew that 2, arguably 3, of the 14 voting members had publicly stated various versions of "we didn't vote."
And that's, just so everyone's clear, that's Minnesota, that's Michigan State, and the third one I think you're arguably saying is Penn State.
Yes. One of those versions was, quote, "we didn't vote." I think everybody understands what that means.
That's pretty crystal clear. If you're a reasonable juror, it's pretty clear.
Yeah, to Jack Nicholson, yeah, crystal clear. And one of the comments was, "we didn't vote per se." I think that's Big Ten collegiality speak for "we didn't vote." And another comment was, it was more of a deliberative process, a collective action. Well, folks, there's an important legal distinction between a deliberative process and a vote. And I'll use this example. If the jury returns to the courtroom at the end of a trial and the judge says to the foreman, "Mr. Foreman, has the jury reached a verdict?" All of us who've been in trials know the foreman responds with yes, and they have voted and they return a verdict. And oftentimes the verdict is verified in open court. In this case, it seems like at least some of the university presidents are saying that if they were the foreperson, they would have said, well, no, we didn't vote, but we talked about it for a while and decided the defendant was guilty. And therein lies the big difference between just talking about it and coming to a consensus that apparently one person gets to assess that there is a consensus. That's an entirely different deliberative decision-making process than having a vote. And I can't understand for the life of me, this is off the charts bad lawyering, off the charts bad decision-making, off the charts public relations, off the charts poor governance. But you would think in that organization, that every organization I've been a part of, big or small, there's been somebody in that organization whose job it is to say, no, that's not a good idea. And looking at that pleading, I looked at it as soon as it was filed. I mean, the minute I saw that in that affidavit, I was just shocked.
And I guess this will kind of transition, Tom, to the second topic I wanted to talk about. We got a copy of this, the brief that was filed by the Big Ten, and it laid out, we didn't have access to it before, but that the Big Ten's bylaws essentially said, in order to reduce the games or cancel the season, you need 60% of the members of that conference. So just doing basic math, that's 9 members have to affirmatively vote to either reduce or cancel, however you want to phrase it. Dan and I had this interesting kind of, legal debate back and forth. I'm not really certain how Big Ten thought that their response was sufficient when they provided just a sworn affidavit from one person, right, from the chairman, be it Northwestern. That's one vote. And he's not even saying which way he voted in his affidavit. I'm on Twitter. Dan and I are both very active on Twitter. And Tom, you now are yourself. Welcome to Twitter, we should say. Tom's on Twitter at Talon Mars, which I think is a testament to his talents. I think that's what that meant. But, I think there is a version here, Tom, where there was just a general, and this is just me speculating, but that's what we do as lawyers. We try to ask the right questions and figure out to get there. If Kevin Warren was leading a conversation and he said, by show of hands, who wants to play the season, right? And 3 people raise their hands, whoever that might be, just by some reports, that's Nebraska, Iowa, and I believe the third, Ohio State. Now, in that version, those 3 people raise their hands and they go, okay, you guys are the ones that want to play, and then the rest of the room doesn't want to play. That's an 11-3 vote. My reading of the Big Ten bylaws would mean that was not a proper vote, because that's only a vote for 3 people affirmatively doing something. And my reading of the Big Ten bylaws say that you need 9 people to vote to cancel the season. Is that your reading and your understanding as well?
That's my reading as well. And it's a good point that I think has not been really emphasized enough in the public domain, but that's my reading as well.
And I want to give Dan some credit too. Dan has been pointing this out. In order to disrupt the rules of a private organization, you need to show some evidence of egregious conduct. And one that Dan has been harping on is evidence that you didn't follow your own procedure. So one would be not following this proper procedure to vote. Do you think that the Nebraska players here could establish that this own vote didn't follow proper protocol? And if they do, what happens then?
Well, I should say that before that lawsuit was filed, when Mike Flood was threatening to file it, I was extremely skeptical, so skeptical that I thought he probably wouldn't actually file it. And I think benefit of seeing what's happened since he's filed it, having studied the lawsuit, not having talked to him, I've never spoken to him, we're not collaborating, but I think that's just an outstanding example of what I'd call courageous advocacy, because that's a high profile case and it could bomb, like on day one. The merits of the actual legal claims for relief are novel, to say the least, but I've watched how he's handled that case. I listened to the transcript of the hearing, and another surprise, because I don't know the lawyer representing the Big Ten, but I know his reputation. I know a little bit about his experience. Wow, what an incredible example of a lawyer being caught off guard in a state courtroom that he's not familiar with. He was out-lawyered by Mike Flood, in my opinion, from the minute that hearing started until it was over.
Yeah, but Tom, I read his responsive brief. I mean, and quite candidly, he might have been caught off guard by the expedited nature of the hearing without having had a chance to brief the issue. And the issue that I raise, and I kind of agree with, is where does player standing come from if you're trying to assert a contractual relationship with an athletic conference when there's all this case law, Hairston versus Pac-10, which stands as the leading case, which rejects the concept of players having third-party beneficiary rights by virtue of governing documents of an athletic conference. And then turning to the tort claim, the tort claim is predicated on a name, image, and likeness law that hasn't even been implemented yet in Nebraska. So my cynicism as an experienced lawyer, not nearly the same courtroom experience you have, is that two words immediately come to mind: home cooking. So I'm not surprised by the result, but is this the end of the battle given the standing obstacles that I think still stand in the way?
Well, I was familiar with the case law you cited, which is why I was sort of doing that kind of thing before this lawsuit was filed. And then when I read the complaint, I mean, it was really well done, but as you guys know, creative, novel, there are other ways you could describe it. But, I think it's safe to say that it'd be a bit of an uphill battle to take that case to the Nebraska Supreme Court, assuming you get that far and have it sustained. But a lot of things happen in courts before you get to that point. And that's when I shifted and said, well, this guy's going to get limited discovery for sure.
Well, I don't think that there's an immediate right to an appeal here because it's an interlocutory discovery ruling, but could there be some kind of intermediate extraordinary writ relief or some other judicial intervention between now and the response deadline? Are you hearing anything about a possible appeal, writ of mandamus, or even removal to federal court?
No, my knowledge of that lawsuit, guys, is no different than yours. I was able to get my hands on a copy of the complaint, and I read commentary. But let me say this: God forbid this was going on in the SEC, but if it was, there were 75 counties in Arkansas. I'm certain that I could find a state judge in Arkansas in one of those 75 counties that would have enjoined the SEC from canceling fall football, regardless of what laws are on the books.
Okay.
Now, I don't know how things work in Nebraska, but having practiced law since 1985, mainly in Arkansas, I can tell you that there are ways to get that done, and within the bounds of ethics too, because judges have different opinions. And one of the things everybody has to keep in mind is that a lawyer doesn't violate any ethical rules when he or she asserts a claim for which there's no legal precedent, as long as that lawyer is willing to acknowledge to the court that he's asking the court to extend precedent that exists in that state. And of course, in this case, the argument might be this case is different. Every case is different from every other case. I agree with your assessment if we were in a law school class, that would be my assessment. That's what I'd be saying to the class, and that's what I'd hope the students would be saying back to me. In the real world, it's not quite that.
Well, he pled right into Hairston. He pled exactly Hairston without distinguishing it. But okay, let's accept the ruling as being the ruling, and it won't be overturned on any kind of intermediate appellate relief. Let's assume that that's the case. What role does your public records request play? Is your role mooted if the Nebraska court ruling gets the plaintiffs everything that they need? What is it over and above that you're trying to achieve for your client?
Well, that's a great question, and it makes it even more interesting that Mike Flood and I are not collaborating. I've never even talked to the guy, hadn't communicated with him at all. But you should think of it as a Venn diagram. I know what the judge has ordered the Big Ten to produce, and I know what I've asked for. And in this letter to Purdue today, I noted that it's been my experience in life when you're dealing with a fluid situation, especially one that could affect a lot of people, it's important to constantly reevaluate your prior decisions and be willing to change course in light of changed circumstances. And I said that in this letter I wrote in response to the Purdue email today, which gave me another new variety of reasons why I couldn't have all the documents I asked for. And yesterday I'd already decided I was going to change course because I think the crux of this problem and the thing that's likely going to restore fall football in the Big Ten, in my opinion, is, strangely enough, this question about the vote. Because from my perspective, the Big Ten presidents have put themselves in checkmate by these comments they've made publicly, which are completely at odds with an affidavit that's in court. They are not going to get everything they want, even if the Big Ten produces everything that the courts ordered them to produce. The approach I've taken is to dramatically narrow my FOI requests in a very targeted way. I've asked for, and there's one that I've sent out to Purdue, but the rest will be sent out later today or this evening. Basically asked for all communications between the president of Purdue University from August 7th until 1:30 p.m. today that were done via email and involved, and I've named the other university presidents and specifically named them in the request, looking for all emails between the Purdue president and any other Big Ten president or Kevin Warren that include about a half a dozen specific search terms: vote, voted, deliberate, deliberated, board as in board of trustees, board of regents, that kind of board.
I don't understand how it's possible that people in that room either A, say a vote didn't occur, or B, it unclear that it if it occurred or didn't occur. People clearly weren't paying attention. You can't have a sworn affidavit from Northwestern, hey, a vote happened, it was 11-3. And on the other end of the spectrum, Minnesota says, yeah, I'm not really sure if we took a vote. So if she's the one that's supposed to have voted, right? And she's saying, I'm not sure if a vote occurred. Listen, this is the type of fuel that you and I and Dan would love to have for a cross-examination. It doesn't make sense to me. I'll put it out there. So
what if one or more of these university presidents failed to consult with their board, but actually voted, but realized when this thing started unraveling that they were going to be in a tight spot because they're getting calls from their board saying, how did you vote? What if that president responded and said, well, we didn't really have a vote? Well, this is just a hypothetical, but I have picked up, I think of myself as an investigative lawyer more than a book lawyer. And I've picked up some intelligence that would suggest to me that that could be an explanation. But it's, in my opinion, they're in checkmate. If that happens to be the explanation, well, maybe they still had a vote. Maybe they did. I still take the position that you do, that vote doesn't have the weight that the bylaws require. But if it turns out that you've got university presidents telling fibs to their board, trying to cover themselves because they didn't actually talk to their board, and if it turns out that their boards really aren't happy with these decisions, I'm just telling you guys, there's no good outcome for the Big Ten here. This thing is unraveling fast.
So I know that you phrase it as a hypothetical, but we should address the elephant in the room. I would say there were two cancellations of Big Ten fall football in the same week. One where I remember Dan Patrick, I think he reported that there was a 12-2 vote and it was canceled. Nicole Auerbach over at The Athletic, all of a sudden, someone gave it mouth to mouth because all of a sudden it wasn't dead. And the report coming from various sources was that, I guess the report that the chancellors hadn't voted, that there was some maybe unofficial vote, but another official vote had to occur. So I'm not sure what happened between point A, point B, but then the season was canceled. So listen, Tom, I'm with you. I just can't for the life of me understand how those things occurred. So the question I want to get you at that I know that's the topic everyone wants to talk about. If the Big Ten is put in a bad situation, if their backs up against the wall, they're in checkmate. The person that hung out to dry, at least from my standpoint, appears to be Commissioner Kevin Warren, who I don't know what to read of it, but spoke with President Trump for, I think the reports were 15 to 20 minutes on Tuesday. To call it like I see it, you speak with a politician, it's fair to, I think, say that there's some political factors going on here. So Tom, I want to turn it to you for your thoughts. Where the Big Ten goes from here, what is going behind the scenes, and what Kevin Warren's role in this is, maybe his job is in jeopardy from all this. So just your general thoughts on that.
As always, I'm going to be honest with you guys. I'd say a couple of things about that. I think it's very possible that Kevin Warren has been thrown under the bus. I think he would probably be the first to admit that even if he has been thrown under the bus, there's some things he would do differently. I'm not taking the pressure off of him, but I am willing to admit that he may actually be the scapegoat here. Another thing that I know will be unpopular with some people to hear is I've never said a word about his son playing football at Mississippi State because I think that's out of bounds. And I mean, it's a great talking point, but I think when you get into situations like this, at least as a lawyer, there are limits, and what his son wants to do, whether his son has the ability to go play, even if his parents don't want him to, it's a family matter. And I don't think it's fair to Kevin Warren for people to bring that up. And I know people listening to this, a lot of them at least probably disagree. That's my point of view.
A couple of quick follow-ups on the public records request. You have 13 different public universities that are involved. Can you tell me when the deadlines are? Because earlier I questioned you about the ability of the universities to kind of run out the clock here and delay delivery of the actual documents, either by insisting on prepayment or lodging bona fide or non-bona fide exemption objections. When are these due? And then what's the next step if you get something less than a satisfactory level of disclosure? Are you prepared to go to court? And if so, on behalf of whom?
There are 11 different state laws involved here. The timeframes in the 11 different statutes vary from 4 days on the short end to 30 days in terms of specified days that they're allowed. And one state says a reasonable period of time, and it's been my experience in Texas with Texas A&M, for example, that they interpret reasonable period of time to mean whenever or never. So you have these different statutory requirements. Most of the statutes also have qualifications or caveats that allow them to extend that time. And the only school that's identified a time frame in which they're going to actually produce documents in the near future is a school that has identified September 8th to 10th as the response time. But that's why I've been asked to send one check myself. I've gotten other indications that there are going to be some schools saying, hey, you need to send us $8,000 before we'll give you these records. I break these down into 3 stages. The first stage in this process is I call the pleasantry stage, where you send an FOI request and they send you back a nice letter. They don't really say anything, but that's just a way to put you off. And then the next step, could be called the combative stage, and that's the stage we're entering now. And that's why I adopted a new strategy. I'm going straight to the core. I'm going to find out everything there is to know about this vote, if there is one, because there is no way with 13 universities in the crosshairs asking for that targeted information between August 7th and today's date, just the president's email communications with other presidents and Kevin Warren. First of all, that's a very limited request. There's no excuses. They can't say, well, you got to pay us $6,000 to get documents. That IT department can run that search in an hour. They don't have any excuse now to say this is going to take us forever. So that's the difference, getting back to your question. This Venn diagram, even if Mike Flood gets everything the judge has ordered them to produce, they're not going to willingly produce what they think are confidential emails between university presidents and other university presidents and their president and Kevin Warren. And it's been my experience, I don't say this disrespectfully to anybody, I have close friends who've been college presidents. As a group, and I'm generalizing, they're not the type of people who stop and think about the Freedom of Information Act before they hit the send button and send an email to somebody. Who thinks that way? Athletic directors and coaches, they do. But it's a lot harder to find the kind of information you're really looking for when you're trying to get it out of the athletics department. But the general rule, university presidents, use email the same way everybody else does. And I'm no exception. There's probably not a person listening to this that hasn't sent an email at some time that they later thought, maybe I shouldn't have said it that way. And they're going to have to answer those. They're going to have to answer pretty soon. And there's just no way out of that track.
So I think, Tom, the third topic I wanted to make sure we get to, and I want to make sure we leave enough time for it. You've talked a little bit about your background helping players transfer from different schools. And then I would be remiss if I don't see Justin Fields' name transferring, is trending every day. I think he was at a Georgia practice recently.
I got a couple calls about that from sports writers yesterday.
Yeah, I see it. So, the lawyer in me, and just like you saw a problem once upon a time, if you were a Big Ten athlete that wants to play football in the fall, right now, right, I'm not sure there's a mechanism to just immediately transfer to another school with absent some type of hardship waiver. Do you think that at some point in this COVID world we live in, with some schools playing in the fall, some playing in the spring, that there is going to be a change in the way that athletes are allowed to transfer, specifically because of this unseen and unforeseen COVID pandemic?
Well, I do. I'm pretty optimistic about it. The transfer working group made a recommendation that was going to be voted on by the Legislative Council in late May, which most people thought, myself included, would result in abolishing that rule and replacing it with a one-time transfer without penalty for everybody. For various reasons, probably mostly because of the pandemic, they again kicked the can down the road, this time to January of 2021. So on the current agenda, the Legislative Council is supposed to vote on that in January 2021. I've given a lot of thought to the question you asked, for obvious reasons, and I've been asked by other people the same question. Solving for that right now would be such a nightmare. I'm not sure it's even possible. There's one exception. If they just go ahead and adopt a one-time transfer without penalty for everybody and maybe do it sooner than January, I think they'll avoid having to deal with this. But, you saw yesterday that all the staff in Indianapolis are going to be put on furloughs. That's not a place to get fast decisions from to begin with. We've all seen crazy examples of that. But think about trying to get a waiver out of Indianapolis when half the people in the building aren't even working. They're not working at home. They're not working at all. I don't see how they're going to deal with that. But since sorry, Coach Saban, I just disagree with you, but I actually think Coach Saban speaks very intelligently about this issue. But I think it's just absolutely inevitable that this rule is going to be passed. And the only reason it wasn't passed in May is because of this pandemic. It's going to happen. It reached the tipping point some time ago. And why not just go ahead and tip it in and be done with it? That's my view.
So, Tom, it's been an absolute pleasure hearing from the source here. And, I know there's a lot more in store. So if you're up to it, we'd love to have you back on in the future.
Well, I enjoyed it. It was fun. Thanks for having me on, guys.
Thank you very much, Tom. Be well, and we'll talk soon. Have a great rest of the day.
Dan and I are obviously going to keep our tabs onto all things Big Ten. I do think it's interesting. If the Big Ten really did want to provide transparency, Dan and I have, at least I've said it, 14 sworn affidavits from those in the room would get it done. Again, maybe the Big Ten's under no legal obligation, but that would really quiet a lot of the noise. Dan, what are your overall thoughts on this before we send it?
What the focus of these lawsuits and public records requests so far are they're trained on the acquiring of information. That's sort of a public relations battle and sort of trying to get at the rationale, but it doesn't force Michigan or any of the other schools in the Big Ten to actually play football. And I'd be interested to see how far the court process can go to actually mandate that affirmative action be taken to play football. Because right now, we're just looking at lawsuits and public records requests solely or primarily for the purpose of securing or obtaining information. We haven't yet reached the precipice of will a court enjoin or restrain or force the Big Ten to do something in the realm of scheduling its season. And I doubt that's ever going to happen.
I think if you read between the lines with Tom, I think he's saying much of the same, but we'll see what that discovery brings. So that being said, that'll put us in the books for another episode of Conduct Detrimental. As always, Dan Wallach is on social media at Wallach Legal. Myself, Dan Lust, on social media at Sports Law Lust. The show, Conduct Detrimental, on social media at Con Detrimental. And again, that'll do it for us. We will see you next week, Dan, on another episode of
Conduct Detrimental. Take it away, Brass
There we
Bonanza.
go. Boom.
You can't handle the truth.